So let's break that down for a second. Somebody's accused of a crime, maybe on videotape, committing cold-blooded murder. So there's really no question factually whether this person did it, because he did. And some state, maybe New York, indicts him on murder. And the person goes into the courtroom at the arraignment. Now, the arraignment, by the way, is the first proceeding in a case. You've been charged with a crime, indicted, whatever the charging instrument is called, and you go into a court, and the first thing that typically happens after some bond hearing and reading of the charges proceedings is something called an arraignment. An arraignment is where you enter a plea, and the plea typically you get a couple or three choices: guilty, not guilty, nolo contendere, or meaning no contest. So the second two are the first and third, guilty and no contest, end up the same way. You're going to be found guilty probably. And then not guilty sends the case down the normal progression of the criminal process. So the person I was debating and talking to and arguing with and discussing this didn't like that somebody who was obviously guilty would plead not guilty. And I hear this all the time in the media, this sort of outrage. How could he possibly plead not guilty? And if you're an insider in the system, meaning you know anything about the system at all, doing criminal defense work or even prosecution work, you know that it would be the opposite is really true. If somebody went in at the arraignment stage in, say, a murder case or a high publicity case or any case for that matter, and tried to plead guilty, now the court would probably stop and say, hold on a second. You sure you want to do that? Some courts I have found don't even let people do that. They would just continue the case and say, we're not going to take your guilty plea right now. Go talk to a lawyer or have another discussion. I don't want to do that. Now, I guess you could theoretically force a judge and say, look, this is my procedure, my arraignment. I'm pleading guilty. Darn it, take my plea. You could do that. But my point is it's an unusual thing. It doesn't happen very often. The reason it doesn't happen very often is because a not guilty plea is really just saying, I want to go through the process. And the process is there for a reason. So I plead not guilty with my client. Then I can file a demand for discovery where I can review the evidence and talk to my client about what the evidence is against him or her.